On Beware today, if you have burnt your fingers investing in company FDs, we tell you the way out. Don't forget to share your travel itinerary with your bank. We tell you all that you need to be careful about before you head to your dream destination. And we address your grievances with your telecom operator. The past decade saw many firms raising funds from the market in the form of fixed deposits. Investors were promised higher returns, and millions of housewives, students, pensioners were all lured into these plans. But now, many of these firms have left their FD investors in the lurch. Today on Beware, we help such investors by guiding them on how to reclaim some of their hard-earned money.
Fixed deposits have generally found place in portfolios of investors seeking secured returns, which is why many companies opted to raise money via the fixed deposit route. Several of these companies tempted investors with the bait of offering interest rates which were higher than what was offered by many banks. With the approval stamp from SEBI and RBI, these companies have raised hundreds of thousands of rupees from FD investors. The bitter truth is that many of these companies have now gone bust and investors have been left in the lurch. Take the case of Lloyd Finance investors. In one such email to Beware, Saroj Das says she has invested 24,000 rupees in a fixed deposit with Lloyd Finance. They were expected to mature on the 27th of April 2001. However, till date, she has not received any returns and may potentially lose out on the principal amount as well. In response to her query, Lloyd Finance says, and I quote, "We inform you that Honorable High Court of Bombay, in company petition, has appointed a special committee with its chairman as retired High Court judge. The special committee, since its formation, is in the process of releasing the payments of principal amounts to the investors who had invested 5,000 rupees or below and claimed. The special committee has now taken up the task to make repayments to the investors who have invested the amount up to 10,000 rupees and claimed. In case above referred complainant is holding deposit below 10,000 rupees, the same shall be paid in accordance with the scheme and availability of funds." Apparently, the complainant has not lodged any claim with the special committee for repayment of deposit. You requested to kindly advise the complainant to lodge the claim before special committee immediately along with details of FDR number. End of quote. In a similar case, Amit Kumar from Jaipur also wrote to Beware claiming that he had made a fixed deposit investment in Delhi-based Escort Finance Limited in 2006. He says his FD now matured to approximately 4.5 lakh rupees, but he has not received a penny yet. In response to his query, Escort Finance said, and I quote, "The Delhi High Court has constituted a hardship committee comprising of some senior advocates of Delhi High Court who were authorized to consider payments to the FD holders of Escort Finance Limited. Escort Limited was directed to transfer its listed shares to this hardship committee, who in turn was directed to sell it in the open market, realize money and remit it to the FD holders. The hardship committee has already sanctioned and in process of payment of sum of approximately 36 crore rupees. As the matter is under jurisdiction of Delhi High Court, Mr. Amit Kumar Jain is advised to approach the hardship committee, who would in turn consider his request and make recommendation for payment." End of quote. These stories are not new or few. The past decade has witnessed firms like Lloyds, Escorts, Nagarjuna, Duncan Industries, Morpen, to name a few, launch fixed deposit schemes amidst much fanfare. But many of them have down shutters. But if you are one of such investors, experts say you still have a fighting chance.
If they are registered company before the Bombay Stock Exchange, they can move with SEBI and Bombay Stock Exchange and form a group of investors, and maybe the SEBI and Bombay Stock Exchange can intervene and put an arbitrator, and then conciliation proceeding can go on. Second best option they have is to go to Consumer Court. Under the Consumer Protection Act, you can go before the Consumer Forum up to 20 lakh, above 20 lakh to the National Commission, to the State Commission up to 1 crore, above 1 crore National Commission Delhi.
Experts say the legal battle in court may continue for over 2 years. In fact, you can also consider filing a class action petition. In this way, numerous affected parties can jointly take the company and its directors to court.
The effect of the order of the Consumer Court is, even those directors, if they are made personally liable, you can recover it by sending them to the jail for rigorous imprisonment under Section 27 for 3 years, and under Section 25 their properties could be attached and monies could be recovered.
Once a company goes bust, normally the court appoints a special committee to look into all aspects of company affairs. This includes steps undertaken to repay depositors and recover outstanding debts. This special committee may be appointed instead of an official liquidator. Fund repayment is allocated chiefly on the basis of priority. First of all, payments due to government is cleared. This is followed by dues to be paid to employees. After tax payment are settled, investor dues may be credited from the balance funds available. And approaching a consumer court can help you get an edge over other investors.
Generally, it is better to move consumer courts or such courts and get the decrees of the court from the court, whether civil court decree or a consumer court decree. You will get a priority as a decree holder, and maybe you will be paid much more than those who are ordinary investors or shareholders.
Alternatively, a scheme of compromise and arrangement may be in force wherein investors are allowed to negotiate returns to be settled. This may be done inside or outside court. But most importantly, investors must approach the committee and lodge a claim. Typically, companies post advertisements in newspapers. Listed companies are required to announce the same to stock exchanges. Very few companies send letters to inform investors of the liquidation process. Experts say investors must pay heed to alarm bells.
Generally, investors are not informed immediately. But if somebody moves for a liquidation of the company and the liquidator is appointed, everybody comes to know by the order of the court, or maybe the company can inform them. The trends are when company is not paying dividend, companies are not paying interest, they inform that we are running into losses, bear with us, we will return your money. That is the sign where company is going wrong, and that is the sign when investors should be alert.
Some investors may recover the principal amount of their investment. Some may not even secure that. Experts warn that before you invest in fixed deposits offering attractive returns, do spend time in assessing the pedigree and financial stability of the company.